Good afternoon, and welcome to today's session covering the regulatory framework and resources to enhance protection of older and vulnerable clients. I'm Paula Cifelli, Manager, Policy and Initiatives in the Investor Office of the Ontario Securities Commission, and I'm joined by my colleagues Michael Tracy, Manager, Investor Research and Behavioural Insights, Jennifer Lee Michaels, Senior Advisor, Policy, and Danica Surgison, Advisor, Policy. Before we begin, and in recognition of the importance of inclusion and diversity at the OSC, we will start today's session with a land acknowledgement. Indigenous peoples of Canada have been stewards of this land. It is important to understand the long-standing history of the lands and waters many of us now call home. Much like the Indigenous wampum belts, where particular bead patterns symbolize alliances, kinships, and land arrangements between different peoples, we too respectfully recognize the traditional territory of Indigenous peoples. We acknowledge the two-row wampum belt, and we recognize that the beaded pattern signifies that neither group will force its traditions or customs on each other, but will coexist peacefully as each group follows its own path. With that, we want to acknowledge that Toronto and the Ontario Securities Commission are in the dish with one spoon territory, a treaty between several nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples. The dish represents the land that is to be shared peacefully, and the spoon represents the individuals living on and using the resources of the land, in a spirit of mutual cooperation and in a manner that does not harm the land. We also acknowledge that Toronto is covered by Treaty 13, signed with the Mississaugas of the Credit, and by the Williams Treaty, signed with multiple Mississaugas and Chippewa bands. Today, as we join each other on this land, we continue to seek meaningful ways to protect the earth and future benefactors for the peace, reconciliation, and healthy environments being heralded by this land acknowledgement. Thank you. Before we begin, we'd like to remind all attendees that today's presentation reflects the personal views of presenting staff and do not necessarily reflect the views of the OSC or any other staff. I'd also like to remind attendees that all information we present on today is general information only and should not be considered legal advice. Following some background and context setting, our discussion will move on to the regulatory framework and provide an overview of the recently published amendments to National Instrument 31103 to enhance the protection of older and vulnerable clients and the tools and guidance they provide registrants to help them address issues of financial exploitation and diminished mental capacity facing their clients, and specifically the trusted contact person and temporary hold provisions. We'll then discuss how registrants can use behavioral insights to protect aging investors, followed by an overview of additional resources we will be publishing to support registrants in implementing the amendments. At the conclusion of our presentation, we will answer questions that we received throughout. So we strongly encourage audience members to submit their questions as they come up during the presentation using the GoToWebinar question function. This will help ensure time to consider your questions and respond to them at the end. In developing the amendments, our research and stakeholder consultations revealed a number of important considerations. Canadians are living longer than ever, and older Canadians make up a growing portion of the population. Market and economic trends indicate that Ontarians will be called upon to make more complex financial decisions later in life than might have been the case for previous generations. For many, however, health, mobility, or cognitive changes that can occur with age may affect their ability to make these judgments later in life, as could susceptibility to financial exploitation and fraud. Given the client relationship, registered dealers and advisors can be well positioned to notice warning signs of diminished capacity relating to financial matters and suspected cases of financial exploitation, but also to protect their clients against financial harm. We recognize that dealers and advisors are not, nor can they be expected to be experts in detecting financial exploitation or in assessing mental capacity. But what we heard from investors their advocates and industry alike is that dealers and advisors did not feel adequately equipped to address issues that might arise as their clients age, even if they're able to identify them, and would be supportive of a regulatory framework that enabled them to do so. So with this and other relevant information to guide us, we published the OSC Senior Strategy in March 2018 to reinforce the OSC's vision of a stronger and more secure financial future for all Ontario seniors. In 2019, the CSA published Staff Notice 31354, Suggested Practices for Engaging with Older Vulnerable Clients, which provides guidance for registrants when engaging with older clients, such as communicating effectively and establishing policies and procedures for escalating issues. The regulatory framework we are discussing today is another key element of the senior strategy. In March 2020, we published for comment proposed amendments to National Instrument 31103 and its companion policy designed to outline how registrants can address situations involving diminished mental capacity or the potential financial exploitation of their clients. And after considering comments, the CSA published the amendments in final form on July 15, 2021. So with that context, we'll now move on to a discussion on the substance of the final amendments that underlie the regulatory framework to enhance protection of older and vulnerable investors. Supported by new definitions that have been added to National Instrument 31103, two components underlie this regulatory framework. The first is the Trusted Contact Person, or TCP. The amendments require registered dealers and advisors to take reasonable steps to obtain the name and contact information of a client's trusted contact person, as well as the client's written consent to contact this individual in certain circumstances, such as where the registrant has concerns about the client's mental capacity to make financial decisions or that the client is being financially exploited. Temporary hold is the second key component of the framework, and the amendments clarify that, provided they take certain prescribed steps, registrants are not prohibited from placing a temporary hold on transactions for or withdrawals or transfers from a client's account where a registered firm reasonably believes there is financial exploitation of a vulnerable client or that the client lacks the mental capacity to make decisions involving financial matters. We'll now review each of these two components in turn, beginning with the trusted contact person. Focusing first on their role, a trusted contact person is a resource for registrants to help protect a client's financial interests or assets when responding to circumstances of possible financial exploitation or concerns about a client's mental capacity. Trusted contact persons can also be a resource for the registrant to confirm the client's contact information, such as in circumstances where the registrant is having difficulty reaching the client, or to make inquiries about the name and contact information of a legal representative of the client. Our intention is that the trusted contact person have sufficient knowledge and understanding of the client's circumstances, like a family member, close friend, or caregiver, to act as a resource in the circumstances I've described. Clients should be encouraged to name as their TCP an individual who they trust, who is mature, and is able to communicate and engage in potentially difficult conversations with the registrant about the client's personal situation. The TCP is not, however, permitted to execute transactions, make financial decisions for the client, or act on the client's account only by virtue of being named a TCP. While a client-designated attorney under a power of attorney can be named as a TCP, clients should be encouraged to select an individual who is not involved in making decisions with respect to the client's account. A TCP should not be the client's dealing representative or advising representative on the account. There is no prescribed form for obtaining TCP information. Registrants may wish to develop a standalone form or incorporate TCP information into an existing form, such as an account application form. The standalone form or relevant sections of an existing form might include an overview of the circumstances in which the registrant may contact the TCP, space to document information about the TCP, including the TCP's name, telephone number, email address, and nature of their relationship with the client, a signature box to document the client's consent to contact the TCP, a statement that confirms the client's right to withdraw consent to contact the TCP, and a description of how to change TCP information, including designating a new TCP. Collecting trusted contact person information is not mandatory. Registrants may proceed to open and maintain an account if the client refuses to identify a TCP. However, as of December 31st, 2021, registrants must take reasonable steps to obtain TCP information at account opening or at the time that KYC information is updated on an existing account. Examples of reasonable steps include explaining to the client the purpose of a TCP, the circumstances in which the registrant would contact the TCP with the client's consent, and asking the client to provide the name and contact information of a TCP. If a client refuses to provide the name and contact information for a TCP, the registrant may make further inquiries about the reasons for the refusal. At each KYC update, clients who have previously refused to provide TCP information should be asked if they would now like to provide the information. I will now turn it to Jennifer to discuss temporary holds, the role of the trusted contact person when placing a temporary hold, and implementation matters, such as developing policies and procedures and transition matters.
Thank you, Paula. I'll now speak about the second key aspect of the amendment, the new temporary hold provision. A temporary hold is intended to be a tool that can be used to protect clients and their assets where a firm reasonably believes that financial exploitation of a vulnerable client has occurred, is occurring, has been attempted, or will be attempted, or that a client lacks mental capacity to make financial decisions. While there's nothing in securities legislation that currently prohibits firms from placing a temporary hold, we heard from industry stakeholders during the public consultation process that a regulatory framework is strongly desired in order to gain comfort that regulatory actions will not be taken against the registrant for the sole reason that they place a temporary hold. Accordingly, the new section 13.19 of National Instrument 31103 essentially creates a framework under which firms are required to meet certain conditions, such as internal escalation, client notification, and documentation requirements when placing a temporary hold in certain circumstances. An important note here is that in order to rely on section 13.19, it's the registered firm and not just the registered individual who must hold the reasonable belief of financial exploitation of a vulnerable client or lack of mental capacity of a client to make financial decisions. In other words, decisions to place temporary holds should be made by the CCO or authorized supervisory, compliance, or legal staff. When placing a temporary hold, registered firms and individuals must act in a manner that is consistent with their obligations to deal fairly, honestly, and in good faith with their clients. As defined in the amendment, a temporary hold is a hold that is placed on a securities transaction or a disbursement from a client's account. A temporary hold is not intended to be a hold on an entire client's account. Transactions unrelated to the suspected financial exploitation or lack of mental capacity should not be subject to the hold, and a temporary hold should not affect the payment of regular expenses, such as the payment of monthly bills. If a registered firm has reasonable belief of financial exploitation of a vulnerable client, or believes that a client lacks mental capacity to make financial decisions, and the firm decides to place a temporary hold, Section 13.19 will require firms to document the facts and reasons that caused the firm to place the hold, provide notice of and reasons for the temporary hold to the client as soon as possible. And firms will also be required to review the relevant facts as soon as possible after placing the temporary hold and on a reasonably frequent basis to determine if continuing the hold is appropriate. If a decision to continue the hold is made, firms will be required to document the relevant facts and reasons that caused the firm to come to that conclusion. While there is no specific time limit under which a temporary hold must be revoked, firms will be required to, every 30 days until the hold is revoked, either provide the client with notice of the firm's decision to continue the hold or revoke the hold. While there's no requirement for firms to reach out to a trusted contact person, firms may wish to do so when a temporary hold is placed. But before reaching out to a trusted contact person, firms should assess whether there's a risk that the trusted contact person is a perpetrator of the exploitation. If the firm suspects that the trusted contact person is involved in the financial exploitation, a notification to the trusted contact person may have detrimental effects on the client. Before contacting any third party with the intent of sharing or seeking personal information about a client, firms are reminded to assess their obligations under applicable privacy legislation and client agreements. For clarity, the fact that a client has chosen not to name a trusted contact person doesn't preclude a registrant from placing a temporary hold in accordance with Section 13.19. This next slide speaks to the general requirement in Section 11.1 of National Instrument 31103 for firms to establish, maintain, and apply policies and procedures that establish a system of controls and supervision sufficient to provide reasonable assurance of compliance with securities legislation and to manage the risks associated with their business. Having written policies and procedures that address situations that may result in contacting a trusted contact person or placing a temporary hold under Section 13.19 will help the registered firm demonstrate that it has a system of controls and supervision in accordance with Section 11.1. Guidance on the types of policies and procedures firms should have is highlighted on this slide. For more information, we would direct you to the companion policy guidance, which was published with the amendments in July. As proposed in the March 2020 publication, the final amendments will come into force on December 31st of this year, at the same time as the Know Your Client provisions of the client-focused reform. In respect of existing clients, as Paula mentioned previously, the expectation of the CSA is that registrants will take reasonable steps to collect TCP information from those clients the first time they update the client's KYC information after December 31st, 2021. And with this, I'll turn it over to Michael Tracy.
Thank you, Jen. Policymaking is a complex process that requires significant time and resources. A lot of very talented and dedicated policy professionals have been working hard to ensure the substance, language, and the technical details of this rule are precise and accurate. But in many ways, creating a rule is really just the first step. The success of a policy is often determined by how well it is implemented. So we undertook a Behavioral Insights research project to assist in the implementation of this rule. So Behavioral Insights is an approach that examines how people actually behave instead of assuming that they will behave rationally or do what's always in their best interest. It draws on psychology and economic factors and really explores the different ways that people are actually making their decisions. So on November 9th, we published our OSC Staff Notice 11790, Protecting Aging Investors Through Behavioral Insights, which identifies behaviorally informed tactics to successfully collect trusted contact person information from older investors. Our research found that one of the forms we tested, which featured behavioral science techniques, resulted in a significant 23% increase in the likelihood that a person would appoint TCP. Behavioral Insights contrasts with the traditional economic approach to policymaking in that it does not expect people to make rational decisions. In economics, rationality has a much more specific definition than we would generally use. So in economics, the rational agent has and understands all information, knows the probabilities of events, determines their preferences based on costs and benefits, and then consistently chooses the self-determined best choice of action. But I probably don't have to tell anyone in the audience that's not how most people make their decisions. But let's look at how a rational agent would approach the decision to appoint a TCP. So let's take an average investor who, when working, had a salary of $75,000 and has accrued $1 million in assets. Assuming a very low risk of vulnerability-based loss of 1 in 20,000, and assuming it takes 10 minutes to make the decision as to whether or not you want to appoint a TCP, we can see that the costs greatly are less than the benefits. So the costs here are $6.25 and the benefit is $50. So even in this kind of simple cartoon model, we can see how most people should want to appoint a TCP. But when we look at other jurisdictions that have a requirement for a TCP, we know that most people are not actually choosing to have one. And we really look to behavioral science to help shed some light on why this might be the case. So there's 3 key elements of behavioral science that we want to cover. And really the first one is this concept of bounded rationality, which occurs when we make satisfactory decisions due to constraints on our ability to optimize. So this usually occurs when we're lacking time or information, or maybe we don't have the cognitive processing power to make the optimal decision. And when we're in a situation of bounded rationality, we often then turn to what are called heuristics. And heuristics are really cognitive shortcuts or rules of thumb that simplify decisions. So instead of going through the arduous process of carefully considering each decision that we make, we often turn to these simple heuristics. And heuristics can really lead to the last thing I want to cover, which is cognitive biases. So these are systematic errors in thinking or a deviation from desirable behavior. Cognitive biases can cause decisions that ultimately lead to worse outcomes for investors. So biases can lead to bad outcomes, but the good news is that biases are systematic, which makes them predictable. So instead of a random error, which you're seeing here on the left, where you can't tell exactly which way the error is going to go, a bias is always in the same direction. And the good thing about that is that we can correct it using techniques from behavioral science. So in our project, we sought to identify and test some of these approaches to improving investor decision making. So the OSC clearly believes that appointing a TCP will help protect older investors from financial exploitation and the negative effects of diminished mental capacity. So our primary goal for this project was to increase the likelihood that someone would appoint a TCP. We wanted to see that uptake number going up. And to do this, we also sought to increase objective comprehension of the role of the TCP and to reduce potential cognitive biases that may lead to worse investor outcomes. So to understand this decision, we undertook a decision mapping exercise to look at the process of deciding whether or not to appoint a TCP. And we broke the process down into 3 parts: comprehension, evaluation, and action. So firstly, looking at comprehension, an investor needs to understand the decision they're being asked to make. And to do this, they need a sufficient level of financial literacy and cognitive ability. The next phase is the evaluation phase. So in this, an investor has to determine, looking at the costs and benefits, as to whether or not the decision is right for them to appoint a TCP. And then finally, assuming they've gone through the evaluation and made the decision to appoint a TCP, they need to follow through with that decision. And it's really in this evaluation and action phase that the biases tend to manifest. And that's really where we wanted to look to increase likelihood people would appoint a TCP by dealing with these biases. So we reviewed literature from behavioral science, psychology, and economics, and found that there were several biases that had a greater impact on decision making as people got older. So some of the key ones that we thought would impact the willingness to appoint a TCP were optimism bias, and this is the tendency for people to underestimate the likelihood of negative events happening to them. So in this instance, it can lead an investor to underweight the risk associated with aging and cognitive decline, or the likelihood of experiencing financial exploitation. Another key one is illusory superiority. So this is really the tendency for people to overestimate their qualities in relation to the same quality in other people who are like them. So this can lead an investor to think that maybe someone else needs a TCP because they're likely to experience cognitive decline, but I won't. As I mentioned earlier, the good thing about biases is that we can design behavioral science interventions to correct them or at least reduce their impact. So we explored using 4 techniques to improve the likelihood that someone would appoint a TCP. So the first one was priming, and this influences people's decisions by triggering a certain mindset. So we primed subjects by having them think about a time that they made a good decision or a bad decision. The next thing we used was a technique called active choice. So rather than just having someone complete a form, we make them actively choose, saying, yes, I want to do this, or no, I do not want to do this. And that active choice really makes the decision much more salient, because in most cases, people are just able to leave a form blank, and they don't have to actually decide that they're not wanting to appoint a TCP in this case. Next, we relied on a concept called social norms. So humans are very social animals, of course, and what we see as the social norms can heavily influence our decision making. So we often try and conform with the group. So in this case, we use social norms to basically inform people of what others are doing in relation to the TCP. And then lastly, we used a technique called a de-biasing boost. So this works by providing a decision maker with very relevant and salient information in the moment that they're making their decision. So in our experiment, we looked at key statistic on the prevalence of fraud. So what we did next was we put our ideas to the test. So we knew that many firms will collect TCP contact information and consent by providing clients with a form during the onboarding process or during the annual Know Your Client updates. So what we did was we designed 3 versions of a form that contained behavioral science interventions. So these forms featured the techniques we just described above, so a debiasing statement, reference to the social norms, and an active choice. They did differ a bit on priming, but we actually found very little or no effects on those. So, and what we did was we used a randomized controlled trial, similar to how vaccines are proven to be effective, to test whether these forms that we designed had an impact when compared to sort of the status quo form that we drew from another jurisdiction that already has a TC policy in place. So this experiment was conducted online with over 900 Canadian investors over the age of 55. So what you're seeing on the screen now is an excerpt from what we would call the control form. So this is the one that was designed to reflect the status quo, and it was drawn from another jurisdiction where they already have a TCP policy in place. And this kind of shows the basic information about a TCP and doesn't really contain anything special in it. And that's where our behavioral forms come in. So what you're seeing now is the version of the form that actually performed the best, while an excerpt from that form. And as you can see, it looks just like the control form, except it contains those behavioral interventions. So the first one you'll see is that we have the boost, which is Canadians lose billions of dollars to frauds and scams every year, and older investors are more likely to be victims of these crimes. So this is, again, that salient piece of information. The next thing you see is the social norm, and this is that 90% of Canadians support the idea of appointing a trusted contact person to help protect their money. So this form also contained that active choice, although it's not shown here on the screen. And these were the results. So this looks maybe a little intimidating, but the main takeaway here is that the most effective version of the form, which is the form you just saw, shown with the bar in orange, 60% of participants said they would like to appoint a TCP, which is a 23% increase over the control form, where only 48.7% of people said they would like to appoint a TCP. So if this finding were to translate to the real world, nearly 1 out of every 5 investors might appoint a TCP because of the elements really contained within this form. So this really demonstrates that the behavioral interventions we propose can influence investors to be more likely to appoint a TCP and then therefore get better long-run outcomes. So the other thing that we wanted to do was really reduce the impact of those biases, right? We didn't just want to essentially trick people into appointing a TCP. We wanted them to actually engage with the decision and actively decide to do it. So we did test to see whether we reduced the optimism bias. And although we did find that all groups were still overly optimistic, again, here in orange, the same version that you've seen was the one that gave them the most realistic understanding of the likelihood of something bad happening to them. So ultimately, we were able to reduce that optimism bias. So what can we distill from all this research? The first thing is that we think it's really important to describe the role of TCP in plain language. So we actually did this in all of the treatments, including the control version. We took a version that existed elsewhere and simplified the language as much as we could. We think that's a very key component to the process. The next thing is that that boost is a really important thing. It really gives someone that important piece of information right in the minute they're making the decision, and it seems to have had a positive impact on the decision makers in this experiment. Next is really drawing attention to the social norms. So we included the reference to the number of people who were willing to appoint a TCP. We think that could continue to have a positive impact. And then lastly, when it comes to actually completing this, force the active choice on people, make them say, yes, I would like to appoint, no, I would not like to appoint. So people who are interested to learn more can review OSC Staff Notice 11790, Protecting Aging Investors Through Behavioral Insights. This notice contains the full research findings and a sample of the most effective TCP form. With that, I will turn it over to my colleague, Danica.
Thanks, Mike. To assist with the implementation of the amendments, the OSC is developing white label materials as a resource and part of the enhanced education and outreach activities included in the OSC Senior Strategy. The white label materials will be available as a series of 2 to 3 page leaflets that firms may refer to or choose to adapt, brand, and distribute to their representatives. The leaflets cover topics such as working respectfully with older and vulnerable clients, as well as identifying and responding to signs of financial exploitation or diminished capacity. The white label materials will also include a leaflet for clients to complete and provide to the individual that they name as their trusted contact person. This leaflet will also include information about TCPs, as well as a space to include contact information for your firm and your representative. The white label materials are intended to be an accessible, optional resource that firms may modify and provide for their representatives to use when they encounter issues that arise with older and vulnerable clients. They will reflect the learnings of the OSC and include practical tips and content from prior publications, including the OSC Senior Strategy, CSA Staff Notice 31-354, Suggested Practices for Engaging with Older and Vulnerable Clients, OSC Staff Notice 11790, Protecting Aging Investors Through Behavioural Insights, as well as the amendments themselves and the associated companion policy. The white label materials are not to be construed as regulation or guidance. While the materials are being prepared to assist firms, they will not replace a firm's own policies, procedures, or documentation. Where the materials touch on regulatory requirements, they summarize the registered representative's role and include prompts for firms to adapt the materials to direct representatives to the firm's policies for more information. Firms that elect to use the white label materials as a resource must adapt them in a way that aligns with their own policies, procedures, and interpretations of their regulatory obligations. Firms should carefully review all content and are responsible for conducting their own legal reviews as may be necessary to ensure compliance with applicable laws and regulations. We expect to publish the materials in late October. When published, they will be made available on the OSC website. In conclusion for our presentation, we've included some references that have been referenced throughout this document. These include the Senior Strategy, Suggested Practices for Engaging with Older and Vulnerable Clients, Protecting Aging Investors Through Behavioural Insights, as well as a link to the amendments and the companion policy itself.